हो गया भाई ये जो सीखनी हो गया.
Good evening everybody, I am Sana Parvez, the legal expert for Hitbullseye. In today's video, we shall be discussing the legal news from 16th to 30th of November. So, proceeding, first we shall be discussing the case of Bhuri Bai versus the state of Madhya Pradesh. In this particular case, what we need to do is, first of all, we need to understand what is bail and what is bail under section 439. So basically, bail can be essentially granted by the magistrate of competent jurisdiction in the first instance, and then again, because bail is granting of bail or cancelling of bail is an important function which is with regards to the liberty of the accused. That is why the ambit of the bail or the ambit of grant of bail and cancellation of bail has to be enlarged. It has been enlarged under section 439 of CRPC. Under section 439 clause 1, the High Court as well as the Sessions Court also have the power to grant bail to the accused, and also under subclause 2 of the same act, that is CRPC, the Sessions Court as well as the Supreme Court can take away this power also or cancel the bail as well. And while cancelling the bail, it can apprehend the person, or it can order the police officer to apprehend the person and commit him to the jail. In this particular case, however, and in other Supreme Court cases as well, there have been certain conditions which have been laid down as to when and how the bail should and should not be granted. The bail is generally granted in very heinous offences, and in offences where the bail is not granted in heinous offences and offences in which the person is a repeated offender. At the same time, when it is found that the person who was being granted bail earlier has broken the conditions of bail, he can be arrested again. Either he can be arrested when a such condition has been broken. These conditions have been laid down under section 437 of the Code of Criminal Procedures. If some of that condition has been broken, or it is found out that the case for which the accused was apprehended was more heinous than than what was previously thought to be, or the accused was trying to abscond from the state. The accused was trying to tamper the evidence. The accused was trying to interrupt or disrupt the process of investigation. He was trying to collude with maybe the investigating agencies. He was maybe trying to influence the witnesses or threaten the witnesses or lure the witnesses, entice the witnesses, something or the other. In all these cases, the bail is cancelled of the person and he is again committed to prison. However, in this particular case, the Supreme Court stated that cancellation of bail cannot be ordered merely on perceived indiscipline on the part of the accused before granting of the bail. So now in this particular case, basically what had happened was that the High Court had cancelled the bail of a woman, stating that she was unavailable during the course of the proceedings. Now, however, but the Supreme Court went into the facts and circumstances, because prima facie it looks like the accused was not making herself available, so she was tampering the administration of justice. At the same time, when the Supreme Court perused through the case and looked at the facts and circumstances in reality, it found out that the accused was basically a mother-in-law who was accused of having murdered the daughter-in-law, or having either murder or culpable homicide not amounting to murder, but the victim had left behind an issue who was a minor child, who eventually becomes the grandson of the accused. So now the accused was the only person who was left for caretaking of the child, and she was supposed to be at home and take care of such duties, and that is why she failed to present herself in the court at some times. Now, in this particular case, the Supreme Court held that it is justified that the woman who was the accused was unavailable because she was taking care of the family. It wasn't like she was a fugitive. It wasn't like she was an absconder. But it was only that she had some other things to do. So she had no malicious intention as such. She had no evil intention. She was not trying to intentionally cause harm or cause tampering in the administration of justice, and it was just the situation that came out to be like this. So that is why, having stated this and having dismissed the order of cancellation of bail by the High Court, the Supreme Court further stated that the powers of cancellation of the bail cannot be approached as if the disciplinary proceedings against the accused. So they're not like they're not close to a disciplinary proceeding against the accused where the accused has to present himself. So it added that section 439 subclause 2, that is cancellation of bail, is envisaged only in such cases where the liberty of the accused is going to be counteracting the requirements of a proper trial of criminal cases. So long as this is not done, an accused should be allowed to stay free and should be allowed to enjoy the benefit of the bail that she is given. Now proceeding on to the next case, which is Faizan Wahid Beg versus the state of Maharashtra. This case becomes a very important case for us, especially in light of the circumstances especially in light of the circumstances that the Chief Justice of India, D.Y. Chandrachud, recently stated that the age of consent should be reconsidered in the case of POCSO. Now, what is POCSO? POCSO is Protection of Children under Protection of Children from Sexual Offences Act. Now, this act was enacted in 2012, and it has been a decade since the enactment of this act. So since the commencement of this act, in order to see the working and in order to see whether this act has actually been a successful act or not, a committee sat down which was held by which was basically headed by Justice D.Y. Chandrachud, in which he said that a lot of people, 1 in 4 cases that is, under POCSO Act are regarding minor consensual relationships. So the intention of the legislature while enacting the act was in order to protect the children from sexual offences, and it was not to imperil them, it was not to incriminate them, it was not to criminalize any kind of consensual relationship between the minors. So basically a lot of times what happens is that one person in this, might be the girl, might be the boy, one person in the POCSO Act is barely minor and the other person is barely major. Say one person is barely under 13, under 18, say 17 years old something, and one person is barely 18 years above. And it can be the boy or girl because POCSO is gender neutral offences. So what happens is, a person is incriminated in this by the family of the other person, saying that it is an offence under the POCSO. However, it is a consensual relationship by the people who have the cognitive abilities, who have the maturity, who have the understanding of what they are getting into. So in this case also, in Faizan Wahid Beg versus the state of Maharashtra, it was held that the girl was 15.5 years of age and the boy was 21 years of age. However, after perusing through the facts of the case and the circumstances of the case, it was held that the girl child who was 15.5 years of age had the cognitive understanding, had the maturity level to get into the relationship, and the relationship was of a consensual nature in which there was no enticement, no threatening, no influence which was undue, and no malicious intention by the boy as such. So that is why it was held that the boy was allowed to be freed on bail in this particular case. The Bombay High Court granted bail to a man who was accused of raping a girl, observing that two were in a relationship, and the girl, though she was a minor, she understood the consequences of these acts. Is the most important thing that you have to see in such cases. Now, in this case, where she voluntarily joined the company of the applicant, and she had categorically admitted that she was in love with the applicant, whether she consented for the sexual intercourse or not is a matter of evidence which is brought in front of the court. Next up, the Supreme Court clarified the evidentiary value of various statements under the Indian Evidence Act. So now in this particular case, that is the state of Maharashtra versus Dr. Maruti Kashinath Pimpalkar, the Supreme Court reiterated certain aspects of the statements under 161 and 164 of the CRPC in light of the provisions of the Indian Evidence Act. Essentially, what are the statements under 161 and 164 of CRPC? And 161 statements are the statements which are given to the police or the investigating officer by the witnesses during the course of the investigation. So these are essentially simple statements that are made by the person, and the person is not bound to say these things truthfully in case these statements incriminate him, or these statements cause forfeiture of his property, or they attract some kind of penalty. So he's free to lie. So he's not bound to say the truth essentially. So that is why the evidentiary value of these statements becomes very, very, very low. And that is why it was said that only in cases of 147 and 157 of the Evidence Act, in the case where under 147 there has to the prosecution has to show some contradiction, or the defense side has to show some contradiction in the statement of the witness, and it has to show some kind of corroboration. Only in that case 161 statement might be used, only in the case of contradiction and not in the case of corroboration. Secondly, for 164 statements are the statements given during the time of investigation only, but the only difference between a statement under 161 and 164 is that these statements are given voluntarily by the witnesses to increase the level of credibility in the statement, and they are given in front of the magistrates. So that is why essentially what happens is the credibility of this statement is increased a little bit, but however even these statements can only be used essentially for contradiction and nothing else, and that is why even these statements, until and unless they are not properly cross-examined and proved to be right, they do hold a very weak evidentiary value. So this is what was held in this case of State of Maharashtra versus Dr. Kashinath Pimpalkar. Next up, in this particular case, basically Vinay Prakash Singh versus Sameer Gehlot. In this particular case, the Supreme Court explained the ambit of section 428 of the CRPC. In order to understand the case, we first need to understand what is section 154 of 428 of CRPC. It is, for example, a person, say X, is arrested at this point of time. He is arrested for robbery. The investigation goes on for 1 year, and a charge sheet is filed against him. The charge sheet goes on for the charge sheet and the trial goes on for say 2 more years, and the judge says that this person is convicted, that the person is actually guilty of the offence, and the judge says that he is liable to undergo a punishment or an imprisonment of 5 years. Now, how will these 5 years be calculated? Should he undergo the imprisonment again for 5 years when he has already undergone imprisonment during the course of investigation and during the course of trial? Suppose if he was already in prison for 3 years, he will only have to undergo an additional of 2 years, so that his punishment of 5 years is completed. So he does not have to undergo more than 5 years, only because of the fact that investigation was going on at that time and trial was going on at that time. So essentially what the Supreme Court held was that Section 428 can be invoked only if the detention undergone by the conviction during the investigation, inquiry or trial is in the same case. So Section 428 provides when the period of detention undergone by the accused to be set off against a sentence of imprisonment. So here, this 5 year, these 3 years are set off against these 5 years, and he has to only undergo 2 additional years. Now what happened in this particular case is that the Supreme Court said that this period will only be counted if this period is in reference to the same offense. This period cannot be counted if this was in reference to some other offense of some other investigation or some other inquiry as such. Alright, next up we shall be discussing the case of Divya Bharti versus the state of Bihar. In this particular case, the Supreme Court talked about the anticipatory bail condition, in which the lower court, that is the Patna High Court, had cancelled the anticipatory bail or declined the anticipatory bail, because anticipatory bail condition directing the panchayat teacher to return her salary was not legally sustainable. So basically, first of all, we need to understand what is anticipatory bail. Anticipatory bail is given under section 438 of CRPC, in which a person who anticipates being arrested by may be granted anticipatory bail for non-bailable offences prior to FIR being lodged. Now in this particular case, what happens is, under anticipatory bails, what happens is, if a person is apprehensive that he is going to be arrested in a non-bailable case, so in order to safeguard himself, he goes to the court directly and states that I apprehend that I will be arrested for so and so case, and please, when I am arrested, please grant me bail. So it is like a preemptive bail. In this particular case, generally there can be conditions which can be imposed at the time of granting of anticipatory bail. These conditions can be that the person who is the applicant is not going to say, there can be multiple conditions, there can be either or any of these conditions, there can be number of these conditions also. So the person is going to inform the authorities if he is leaving the state, the person is not going to leave the country, the person is going to inform the authorities if he changes his residence, the person is not going to do some further crimes, the person is not going to get involved in the investigation or try to influence the investigation, the person is not going to come into contact with the alleged victim, etc. So there are multiple conditions, and all the intention behind putting all these conditions is essentially in order to ensure that the administration of the justice remains smooth. However, in this particular case, the condition that was put by the Patna High Court was that the person who was the applicant has to surrender her salary, which is not justified at all, because that is her means of living. So that is why the Supreme Court struck down this condition and set this anticipatory bail cancellation aside. Next up, we shall be discussing the case of Giresan Nair versus the state of Kerala. In this particular case, the Supreme Court held that even a TIP conducted in the presence of a police officer is inadmissible in the court of law. Meaning to say, for this purpose, we need to understand first of all what a TIP is. TIP is test identification parade, which has been discussed under section 9 of the Indian Evidence Act and 54A of the CRPC. Now, particularly a test identification parade is in case if the accused is not known very well by the witnesses, then in case if he is not sufficiently known in the cases, if he is a thief or a robber, etc., then the witnesses are lined up. It is basically during the time of investigation that the police officers approach the magistrate, and the magistrate gives an order for a TIP. After the order is obtained, similar looking people, the people who look similar to the accused, are lined up in front of the witnesses, and the witness has to identify which of the person was the accused. So in order to ascertain that the case that is going on against the accused is actually correct and actually based on prudent or cogent knowledge of the witnesses. So in this case, if the police officer is present, then there is an apprehension that the police officer might have influenced the witness, and the TIP might not be correctly done. So that is why it becomes imperative that the police officer should be absent at the time of such TIP. So with this, we will wrap up today's session. Thank you so much, and I hope you all like the video. If you did like the video, then please do share, like, subscribe, and stay in line for the upcoming videos. Thank you so much.